The government has proposed amendments in the rules of Section 79 of IT Act 2000, which make it mandatory for the online platforms to actually censor quote unquote unlawful content. It also urges them to end the end-to-end encryption of content. This has come right after the last week's order by the MHA, which actually gave power to 10 surveillance and intelligence agencies of India to monitor and snoop on the computers of the Indian citizens. To talk on these issues, we have right now with us Senior Advocate Vivek Sood with us. Sir, my first question to you is regarding this order which has come by the side of the MHA. But sir, first I need to talk about this recent development which suggests that there have been amendments made on the part of the government which actually tells the online platforms to censor quote unquote unlawful content. Sir, what can you tell us about it?
First of all, they have not, it appears that unlawful content has not been defined.
Exactly.
Now, what is unlawful is very subjective. It has to be defined very specifically. And see, freedom of speech and expression is a fundamental right. Right to privacy has been recognized as fundamental right. And interaction, freedom of interaction, etc. is also part of Article 21, the right to life and liberty. Now, prima facie, these amendments appear to be unconstitutional. They appear to be clearly in violation of the freedom of speech and expression, the right to privacy, the right to life and liberty. And, I'm quite unhappy viewing or hearing or reading about these amendments.
Okay, sir. Sir, if we talk about the last week's order by the MHA, if you can tell us more about it, sir. The BJP is saying it's not the new order, it's the same old order. They have only just reduced the number of the agencies, but we still have 10 agencies in that. If you can tell us and give us more information about that order.
Assuming the order is a repetition of the earlier order of 2009, and does not in any way enhance its constitutional validity, merely saying that because the previous government had brought in a similar order and we are only repeating it and we have reduced the number of agencies or only increased the number of agencies, makes no sense. It does not, it must stand the test of constitutionality. And this order which has come now in 2018, especially after the judgment on the right to privacy being recognized as a fundamental right, such an order also appears to be unconstitutional. First of all, let's understand its constitutional validity. It is settled law that the object of the legislation does not validify it. The object of the legislation may be very good. The intent may be very good, but that does not mean it is constitutionally valid. The test of constitutional validity is the effect of the legislation on the rights of the individual. And the order in question is clearly a violation of Article 19(1)(a), that is the freedom of speech and expression and the right to privacy. The moment you have 10 agencies, who can watch me, who can see my data in real time, or who can get into my communication, my interaction, whether on the telephone or through the email or through other social media platforms. It's a clear violation of the right to privacy, irrespective of your intent or irrespective of how good the object may be. That's one aspect. The second aspect is, no right is absolute. So I'm not saying that I enjoy or a citizen enjoys an absolute right to privacy. What I'm advocating, what I'm saying is that the exception has to be very narrow. The right to privacy has to prevail. Even if many a crime go undetected, the right to privacy must prevail. Only for very narrow considerations, maybe only where you want to unearth an international terrorist conspiracy, or you want to crack a terrorist incident. Only maybe for such narrow purpose, privacy can be taken away, or some agencies may have the power to get into my communication or my interaction. But to say that 10 agencies have the power, including the income tax department. Now I'm interacting with my chartered accountant. Does it mean that the state agency, the income tax department, will have the right to maybe intercept that communication with my chartered accountant? So this kind of legislation, in my view, is in clear violation of the right to privacy. It is not sustainable constitutionally. I hope it is challenged by some NGO or some body or some institution. I'm sure it will be challenged, and then the court will decide upon its constitutional validity. But in my view, this notification is constitutionally, invalid, and it deserves to be struck down.
But sir, the government has been saying that the rebuttal of Arun Jaitley was that we have a committee in Home Ministry where we have Law Secretary, we have Telecom Secretary, we have Home Secretary to actually think and ponder upon this fact that who needs to be tapped, who needs to be taking this care of. So if we see in that regard, they are saying that we will not intercept or we will not tap everybody. Do you think that it can be misused and the order can be misused by the agencies?
See, let me try and counter this argument. This argument is that, the state agencies, the agencies who have been empowered to intercept communication will not misuse their power, because there is a high-powered committee or there is a high-ranking official, the secretary, home secretary, etc., which will grant that permission or the consent or the sanction. But see, first of all, the question is whether this is violative of my right to privacy or not. It is a violation of my right to privacy. You may try and justify it on the grounds that it will not be misused, but that's a second aspect of it. First of all, if there is a violation of my right to privacy, the matter ends over there. It has to be withdrawn, or it has to be struck down, or it is constitutionally not sustainable in my view. So therefore, I feel that this argument is not as meritorious as it appears to be. But being a senior minister and representing the government, that's the best argument the government can give to try and sustain such legislation. I repeat, the objective of this order, this notification, may be very laudable. That you want to check crime in the country, you want to eradicate criminality in the country, you want to bring to book the economic offenders, etc., etc., etc. The objective may be laudable, but that's not enough. If to sustain its constitutional validity, the moment it is violative of my right to privacy, I think it's the end of the matter. It has to be struck down. Again, I repeat, there may be certain exceptions, but exceptions have to be very narrow. They have to be narrowly worded. I repeat, maybe national integrity issues. Again, national integrity is again a very subjective expression. Let us amplify it. Let us clarify it. I think maybe terrorism. any anti-terror strategy may be sustainable. Should be sustainable. Not, it can't be used for investigating all and sundry offences. So I strongly feel that this notification is not constitutionally sustainable.
Okay, sir. Thank you for talking to us, sir. Thank you so much. This is Alin Chauhan reporting for ETV Bharat.